Okay, in today's presentation, I am presenting on the topic reference, review, and revisions. Here we have to see section 113 for reference, sections 114 for review, and section 115 for the revisions under the Civil Procedure Code. Now, at first section 113 reference. Here, sections 113 of the Civil Procedure Code enforce the subordinate code to refer the case to the High Court if they faces some doubt about the questions of law. If there is reasonable doubt by the subordinate court about the questions of law, in these cases, the subordinate court they can refer for opinions to the High Court. Here, such opinions can be sought by a subordinate court when the court when the court trying a suit, appeal, or execution proceedings entertains reasonable doubt about the question of law. Reference is always made to the High Court. You remember that? Reference is always made to the High Court. Reference is always made pending a suit, appeal, or execution proceedings. Here, and you remember that this reference is made always about the pending of a suit, appeal, or execution proceedings if the subordinate court they have some doubts about the questions of law. Here, in reference, it is the subordinate court and not the party which refers to the High Court about the case. Yeah, it is the subordinate court which has been trying the suit, appeal, or execution proceedings. If they possess some reasonable doubt about the questions of law, they will refer to the High Court, but not the party. You remember it. Here, the grounds of reference relate to reasonable doubt on question of law. Here, the underlying object for the provision for reference is to enable subordinate courts to obtain, in non-appealable cases, the opinion of the High Court in the absence of a question of law, and thereby avoid the commission of an error which could not be remedied later on. And the main object of this reference is that in cases of the non-appealable order judgments, in the absence of questions of law, here the subordinate courts they can refer to the High Court so that error may not be committed and for the proper dispensation of justice. Here, now the conditions for the reference we have to see. Here, the right of reference, however, is subject to the conditions prescribed by the Order 46 Rule 1. Unless they are fulfilled, the High Court cannot entertain a reference from a subordinate court. Yeah. Whatever the procedure provided under Order 46, it must be satisfied by the High Court. Then only the High Court will entertain such a reference for such a reference by the subordinate court. Here, number one conditions: there must be a pending suit or appeal or execution proceedings uh, in which the decree is not subject to appeal, and the decree or order which is not subject to appeal. You remember that, in which the order or decree is not subject to appeal, or a pending proceeding in execution of such decree. And number two conditions: a question of law or usage having the force of law must arise in the course of such suit, appeal, or proceeding, and whether a particular law or usage having the force of law or not. Yeah, some reasonable doubt about this must arise in the subordinate court. And the court trying the suit or appeal or executing the decree must entertain a reasonable doubt on such questions. Yeah. Now the question of law on which a subordinate court may entertain a doubt may be divided into two classes. Here, those which relate to the validity of any act, ordinance, or regulations. Here, number one, these questions of law must be in relation to the validity of any act enactment by the legislature, that is the statute, an ordinance, or some regulations, whether they have having the force of law or not. And in these cases, and some other related questions, and about the validity of the act, ordinance, or regulations. Yeah, it is obligatory if the some conditions are fulfilled. If the subordinate questions has reasonable doubt about the validity of act, ordinance, or regulations, here it is obligatory for the subordinate court to refer to the High Court for the opinions in the following grounds. Number one grounds, you see, it is necessary to decide such questions in order to dispose of the case. For the proper disposal of the case, such opinion is necessary from the High Court. And the subordinate court is of the view that the impugned act, ordinance, or regulations is ultra vires. And the subordinate court, if they think that whatever the questions relating to act, that is the impugned act, ordinance, or regulations, now it is the beyond of powers, not having the force of law. That is. And number third, There is no determinations either by the Supreme Court or by the High Court to which such court is subordinate, that such act, ordinance, or regulations is ultra vires. And number third grounds is that here the Supreme Court is not yet decided that such act, ordinance, or regulations is ultra vires. This reasonable questions of law and doubt by the subordinate court must have to be arise. And the object of the provisions is to see that the act of legislature should be interpreted by the Supreme Court in this state. And whatever the act of the legislature, if the subordinate court they have in reasonable doubt, then in such cases the Supreme Court it must be interpreted about this, about the validity of this act, about the validity of such ordinance or regulations. Then only the subordinate court, based on this act, ordinance, or regulations, they can give the judgments, they can dispose the case. Now, you see the revisions, not revision, the review. Now the review under section 114 of the CPC. Yeah, section 114 of the code gives a substantive rights of review in certain circumstances, and order 47 provides the procedure therefore. Here, the provision relating to review constitutes an exception to the general rule that once the judgment is signed and pronounced by the court, it becomes functus officio, ceases to have control over the matter, and has no jurisdiction to alter it. Now, this review concept, it is an exception to the general rule that whatever the judgments or order already given by the court, it cannot be altered or it cannot be changed. It is an exception of this. A review is an exception to this. Yeah. In legal parlance, review means a judicial re-examination of the same case by the same court and by the same judges. Here you have to remember that this review is the judicial re-examinations of the case by the same court or by the same judges. Here, in review, a judge who has disposed of the matter reviews an earlier order passed by him in certain circumstances. Here, reviews lies to the same court. Here, the review, it is always lies to the same court. That means who have given the judgment, who have given the decree, who have given the order, it lies to the same court. Here, review of his judgments involves reconsiderations of the same subject matter by the same judges. Here, an application for review can be made only after the decree is passed or order is made. And this application for review can be made only after the judgment or decree it has already been passed by the court. Here, the remedy of review, which is a reconsideration of the judgment by the same court and by the same judge, who has been borrowed from the courts of equity. Now, this concept of review by the same court and by the same judge, it has been borrowed from the principles of equity, based on the reasons, based on the conscience. Here, the basic philosophy inherent in the recognitions of the doctrine of review is acceptance of the human fallibility. If there is an error due to human failing, it cannot be permitted to perpetuate and to defeat justice. Such mistakes or errors must be corrected to prevent miscarriage of justice. Here, this review, it has been borrowed from the principles of equity because all humans may commit mistakes or errors. That's why it must be rectified, it must be corrected by the same court, by the same justice, based on the principles of reasons, uh, good conscience, that is. A person aggrieved by a decree or order may apply for review of his judgment. Here, an application for review of his judgments may be made on the following grounds. Here, under the grounds on which the application for review can be made. Here, number one, discovery of new and important matter or evidence. Here, this review application can be made by the parties for the discovery of new and important matter and evidence. Some evidence may be lacking at the earlier decision judgments. Yet some matter may be lacking. In these cases, this review petition can be made by the parties. Or a mistake or error apparent on the face of the record. And any other sufficient reasons. If there is mistakes or error reference on the face of the record. If it is distinguished hinted, there is some mistake, some error or disjustments, then under these grounds, the party they can apply for the review of this judgment, decree or order. Here, it is well settled that the power of review is not an inherent power. We have to remember that this review power is not an inherent power. It must be conferred by law, either expressly or impliedly. Yeah, it may be given expressly or impliedly by the statute itself. We have to remember about this. Review is not an inherent power. Now the revisions, section 115 of the CPC. Here, section 115 of CPC provides that a revisions application lies only to the High Court. A revision application lies on the ground of jurisdictional error. In case of jurisdictional error, this revisions a petition can be made by the party or on the shoe motto of the court. Here, the revisional force of the High Court can be invoked only in those cases in which no appeal, either first appeal or second appeal or a appeal from an order, lies to the High Court or to any subordinate court. Here, this revisional power can be exercised from the judgment or decree where no appeal from the first appeal or second appeal or appeal from an order lies to the High Court. We have to remember about this. Here, while exercising revisional jurisdictions, the High Court can not interfere with an order passed by the subordinate court. Hmm. If it is within its jurisdictions, even if it is legally wrong. Here, the High Court has no power to interfere the decision or judgment by the subordinate court if the subordinate court they have been exercised within their jurisdictions, although it may be exercised illegally. If jurisdiction is okay, then the High Court cannot interfere this judgment, decision, decree, whatever given by the subordinate court. Here, the High Court cannot decide a question of fact in the exercise of its revisional jurisdictions. Here, at the exercise of revisional jurisdictions, the High Court cannot decide the question of fact. That is, the High Court may decline to interfere in the revisions if it is satisfied that substantial justice has been done. Here, the revisional power of the High Court is purely discretionary. Here, the High Court cannot interfere if the subordinate court has given the substantial justice within their jurisdictions. If it is satisfied by the High Court, then the High Court they cannot interfere. The High Court can interfere only in the jurisdictional error by the subordinate court. We have to remember about this. Here, the filing of an application is not necessary in case of revisions. Here, an aggrieved party may invoke the jurisdictions of the High Court by filing an application, or the High Court may exercise the revisional jurisdictions even suo moto or of its own motion. Yeah, these revisional jurisdictions can be exercised by the High Court suo moto on its motion or even on the application of the party against its judgments, decree, or decisions. Here, now the underlying object of section 115 is to prevent a subordinate court from acting arbitrarily, capriciously, and illegally or irregularly in the exercise of their jurisdictions. Ambition of revisional jurisdiction is that so that the subordinate court may not exercise arbitrarily, capriciously, or illegally. That is, the subordinate court must have to exercise within their jurisdictions. Ambition of this section 115 is about that. Here, it enables the High Court to correct when necessary errors of jurisdictions committed by subordinate court and provides the means to an aggrieved party to obtain the rectifications of a non-appealable order. Here, in case of the jurisdictional error, the High Court can correct it about this, and the party, aggrieved party, they can obtain the rectifications about this. Yeah, the revisional power under Section 115 of the Code is clearly in the nature of a power to issue a writ of certiorari under the Article 226 of the Constitution. Hmm. It is, however, not as wide as certiorari, since it can be exercised only in case of a jurisdictional error and not in the case of any other error. Yet, this revisional power under Article 115 of CPC can be compared with like the writ of certiorari under Article 226 of the Indian Constitution. But this revisional power is not as wide under Article 26, under Article 2026 writ of certiorari of the High Court, because the revisional power can be exercised only in case of the jurisdictional error only. Yeah. Now the nature and scope of the revisional jurisdictions. Yeah. Section 115 authorizes the High Court to satisfy itself on three matters. Yeah. Number one, that the order of the subordinate court is within jurisdiction. Whether the subordinate court they have been exercising within their jurisdiction or not. And secondly, that the case is one in which the court ought to exercise its jurisdictions, and whether the subordinate court they could not have exercised whatever the power given to them, whatever the jurisdiction given to them, whether it can be exercised by the subordinate court or not. Jurisdiction is given by the subordinate court, whether they could not exercise or not, whether they have been exercised or not about these jurisdictions. And number third, that in exercising jurisdictions, the court has not acted illegally. That is in breach of some provision of law or with a material irregularity. That is by committing some error of procedure in the course of a trial, which is material in that it may have affected in the ultimate decision. And that in exercising jurisdictions, the subordinate court, they had not been done illegally. They have not been done the material error. These three conditions. If these three conditions are satisfied by the High Court, then the High Court cannot interfere the judgment given by the subordinate court. But if the subordinate court is not in compliance with these three conditions, then the High Court can interfere. The High Court can rectify whatever the judgments or decree given by the subordinate courts. Here, here up to this, we have been clearly discussed about the concept of the reference, concept of the review, and concept of the revisions. Okay, that's all.